Start. The receiving state shall be bound by the legal nature and duration of the sentence as determined by the transferring state. Stop. If, however, the sentence is by its nature or duration or both incompatible with the law of the receiving state, or its law so requires, that state may, by court or administrative order, adapt the sentence to a punishment or measure prescribed by its own law. Stop. As to its nature and duration, the punishment or measure shall, as far as possible, correspondence with that imposed by the judgment of the transferring state. Stop. It shall, however, not aggravate, by its nature or duration, the sentence imposed by the transferring state. Stop para. Insofar as the conviction and sentence of the respondent is concerned, he travelled twice to Mauritius in the guise of doing business in scrap metal. Stop. On the third occasion, he was found to be in possession of 152.8 grams of heroin and was arrested. Stop. The Supreme Court of Mauritius convicted the respondent after taking into account the mitigating circumstances pleaded by the respondent and sentenced him to imprisonment for 26 years. On 9/10/2015, an undertaking was given by the respondent that he will abide by the terms and conditions of the sentence adaptability order issued under the agreement/treaty on transfer of sentenced prisoners entered into between India and Mauritius while making a request for his repatriation to India. Stop. Subsequently, his repatriation to India was approved on 4/3/2016 and a warrant of transfer was issued on 24/10/2016. Stop para. After the transfer of the respondent to India under the 2003 Act, the respondent preferred a representation to the Ministry of Home Affairs, Government of India for reduction of sentence from 26 years to 10 years, which is the maximum punishment prescribed under Section 21 subsection B of the NDPS Act as applicable for the quantity of heroin seized from the respondent. Stop. By an order dated 3/12/2018, his representation for reduction of sentence term was rejected. Stop para. While allowing the writ petition filed by the respondent, the High Court was of the opinion that if the offence was committed in India, the respondent would have been sentenced to for a maximum period of 10 years as provided in Section 21 subsection B of the NDPS Act. Stop. The reason given by the authorities for not accepting the request made by the respondent for reduction of sentence by 10 years was found to be not justifiable. Stop para. The rejection of the request of the respondent was found to be in violation of Section 13 subsection 6 of the 2003 Act. Stop. On such findings, the High Court declared that the respondent was entitled for the benefit of adaptation of sentence in terms of Section 13 of the 2003 Act. Stop. Notice was issued by this court on 26/8/2019 in the SLP and the judgment of the High Court was stayed. Miss Madhavi Diwan, learned Additional Solicitor General for India appearing for the appellant, relied upon the statement of objects and reasons of the 2003 Act to submit that the receiving state is bound by the legal nature and duration of the sentence as determined by the transferring state, though the enforcement of the sentence is governed by the law of the receiving state. Stop over.